Hi, it's Mike DelSignore, and today I want to talk about how long is it going to take to get a domestic assault and battery case resolved. It's a common charge. I help people with domestic assaults and batteries all over Massachusetts, and I've answered this question a lot, so I want to give it a long and detailed explanation so you know why these cases sometimes take longer than people think. So I'm a criminal defense attorney. I've been helping people deal with domestic assault and batteries and other criminal charges for my entire career. My passion is to help people get their life back together. So when you charge with domestic assault and battery, often the situation is that the person who's claiming to be the victim, whether your wife, your girlfriend, doesn't want to go forward with the case. So most people think, well, this should be easy. The case is going to be resolved quickly. It's no big deal. She doesn't want to go forward. Why is this going to take a while? Well, unfortunately, it does take a while. And the reason is that prosecutors don't want to be on the record as being soft on a domestic case. So when you go in for your arraignment, the case almost never will get dismissed. Even if the person who's the victim goes to the police or lets the DA know, I'm not on board, want the charges to dismissed, they're going to say, the charges are taken out by the Commonwealth, and while we will jot down your wishes, we're still going to prosecute the case. So what happens is then the government will look for other things. They'll get other court dates, pretrial dates, and they'll try to find out if there's any independent witness, if there's a 911. And usually the 911 is really the key piece of evidence. Usually there's not independent witnesses. Typically these cases happen in the home where it's just the husband and the wife together or girlfriend, where there aren't any independent witnesses. These cases can, and I've had them certainly where they happen in public places, but typically they happen in the home where there's no witnesses. The children might be around, but as a practical matter, there's no witnesses that can be called to testify. So why is the 911 call so important? Because that's the way the government can possibly prove the case if the victim's not on board. So technically, the government can call some witnesses. So if it's your girlfriend, the government can say to your girlfriend, well, we respect your wishes, but we still want to prosecute the case. We can force you to testify. That generally doesn't happen. Now, if you're married, you have a spousal privilege. So there's two privileges that come into play. The victim has both a Fifth Amendment privilege and a spousal privilege. So if you're married, the government can never force you to testify against your spouse. If there's an allegation where the husband's charged, or in this case we'll say they're not married. Let's say it's male is alleged to have struck his girlfriend. If the girlfriend may have a Fifth Amendment privilege if she could have been charged too, if it was sort of a mutual situation. So there's two privileges. You get the marital Fifth Amendment privilege. But like I said, typically they're not going to force somebody to testify. So generally they're looking for the 911 tape. The 911 tape can allow them to prosecute the case even if the victim is not on board. And the reason is that the court has said that a 911 call, when somebody calls 911 and says, my husband just struck me, get an officer over here, that isn't testimonial. So normally the rule in court is if evidence is going to come in, you got to have a witness on the stand. That's the Sixth Amendment. It's the right of confrontation. A lot of people have heard the term hearsay on legal shows and on TV. Well, hearsay is an out-of-court statement used to prove the truth of the matter. So if someone out of court says something, that's hearsay regardless, and there's a lot of different exceptions. But one of the exceptions to the hearsay rule is that if something happens sort of as an excited utterance. So the idea is that this cry for help is an excited utterance designed to get help. And it's admissible because the court says it's non-testimonial. Now, you don't have to know all the language of this. This is really kind of lawyer talk at this point, but you should understand it because it's going to help you understand, well, why is this case taking long? What are the issues in court? What are they talking about? So I want you to know the terms and to kind of understand where the arguments are going in court. That way you can be better informed, you'll have less anxiety, you'll know what's happening. So if something is considered testimonial, that means it's like testimony and it should not come into evidence. So if if you, let's say it's the boyfriend is alleged to have struck his girlfriend, and 20 minutes later the girlfriend calls 911 while the boyfriend's not in the house, went to work, and says, earlier today my boyfriend hit me. Now that would be basically testimony, be a report of a crime. They're not in the heat of the emotion, the heat of the incident at the time. So the court wouldn't allow that type of testimony in. Similarly, and I've had this too, let's say the wife walks to the police station to make a report. That shouldn't come in either. Any statement made to the officer, when the officer comes to the house, any statement made to the officer, all those statements should be excluded. So those are all what we call testimonial statements, because they're like testimony. It's the equivalent of testimony. Where it gets more confusing and like a closer legal issue is if the incident's still going on, and this happens a lot. The person gets on the phone, my boyfriend's in the next room, he just struck me, get an officer over here. That's the type of statement that courts have let into evidence and can come into evidence. So what would the trial be like? Well, the trial would be just the 911 and the officer's testimony. So of course, if the defendant, the person charged, and makes admissions, says, yeah, I did strike her, then they have the 911. That would be a stronger case than if they were going to pursue the case. They possibly could get a conviction on that type of situation. Often they don't go try to prosecute cases based on 911 calls. So this issue is something that we would have to determine if they can prove the case without the victim testifying. So after the pretrial, or there could be a couple pretrials, you'll get a 911 call. Then you'll generally put the case down for trial. Now, when the case is down for trial, if the government is not going to try to prove the case without the victim, or if they can't do so, the case would get dismissed. So these cases can take, in other words, if there's no 911 call and husband, wife, no 911, or if the tape, say the husband called 911, the police come, but the husband gets charged. In a situation like that, there's probably not going to be an independent way to prove the case. That case should move quickly from pretrial to bench trial to a dismissal. Where it can take longer is if there's these 911 calls, the government, the prosecutor may want to look into this. They may say, well, we're going to still go forward on the 911. Then the case would be I would generally put the case down for bench trial, do a motion eliminate to try to exclude the 911. If that was successful, the case would end. If it wasn't, depending on the judge, maybe we would go forward with the trial. Maybe then we'd put it on for a jury trial or attempt to resolve it. So the cases can take anywhere from, say, 3 to 6 or 7 months, I would say. Generally, I'm looking, when I say the case is going to end, I'm looking to get these cases dismissed. Anyone can always plea or admit to the charge, and the case would go much smoother. But my goal for all my clients is to get the charge, so it's not going to affect you in the future. It's going to be a dismissal or not guilty. That's our primary goal. There are certainly people who have a bad record and looking at jail time, and certainly in those situations we'd look to resolve the case. But any questions, feel free to call me, Michael DelSignore. You can call, text anytime, 781-686-5924. I'm here to help.